Hi everyone, my name is Marcella Dominguez and I welcome you back to my channel. In today's video, I am talking to you about the USPTO and some basic facts regarding trademarks. Now, if you are new to this channel, I help small and medium-sized companies protect their brands like their company names, their slogans, their logos, and their taglines. Continue watching if you want to learn more about what the USPTO does and how they are going to help you protect your brand. Well, and besides the obvious, I will help you protect your brand as well. So my goal here is that you learn more about the USPTO than you knew before you started watching this video. Make sure that you scroll down into the links below so that you can feel more confident about walking this DIY journey with someone who is more experienced. So fact number one, the USPTO is going to require you to have a lawyer in the event that you are a foreigner. So if you live outside the United States or you are not a United States citizen, then you are going to need a lawyer. You see, the USPTO recently changed their rules because before they established this rule, it was okay for anybody, say in Portugal, Spain, and any country in South America, to go ahead and file a trademark application without a lawyer. So it didn't really matter where in the world you were. If you were an individual, if you were a business entity, you could file an application through the USPTO without a problem. Well, over the course of time, I can only guess that the USPTO has seen a huge influx in trademark applications. In order to make the process a little bit smoother, the USPTO now requires foreigners to have a trademark lawyer in order to transact business on the USPTO website. So now that means if you're somebody who is in Spain, in Portugal, in Colombia, in Argentina, then you are going to have to get a lawyer, a trademark lawyer, to help you register your trademark here with the USPTO. Fact number two, the process of obtaining a registered trademark can take anywhere between 12 to 18 months or so. And that is a fact. You see, at the USPTO, they already have an established system for the trademark application journey. So that means that initially when you submit your trademark application, it is going to be assigned to an examiner. Now, typically that should take only around 3 weeks, but it could take longer, especially with our current COVID circumstances. So the USPTO doesn't really do anything to expedite your application. There are only exceptional circumstances. But I digress because fact number two is all about the process that your application has to follow, and standard procedure doesn't change much unless a new rule is implemented. So as of right now, it's going to be assigned to a trademark examiner. After that, the trademark examiner will look at your application thoroughly. They will check it for any mistakes, any missing information. They will see if there are any issues which would preclude registration. So if there is an issue, then they would issue something called an office action. If there is a problem, they will let you know inside of that office action. Now, an office action is just a fancy way of saying these are the issues with your application. So if you're interested in finding out more about what an office action is, make sure that you watch this video. So after an office action, if you receive one, then your application will move on to publication. Now, publication is also a little bit of a fancier way of saying that we are going to put it in something called the Official Gazette. The Official Gazette is the public's opportunity to look at a mark that is going to be registered and oppose it if they'd like. It's the equivalent of when a priest or somebody officiating a wedding saying, if you oppose this matrimony, then stand up and speak up or forever hold your peace. It is basically the equivalent. So if you oppose someone's trademark registration, then you can do so during that publication period, and it lasts for 30 days. If nobody opposes it, then it will move on to registration. So you could see how the time varies between, 9 to 18 months, 12 to 15 months, maybe 13 months period. So it all depends on whether you have issues or not. USPTO fact number 3. A trademark is going to help me protect my brand or my company name or my company slogan or tagline, and it will also help me protect a sound. That is correct. It's just a fact that if you want to go ahead and protect your company name so that nobody can use it in a similar industry or in a confusingly similar, way, then yes, you want to go ahead and protect that with a trademark. A trademark is what is going to allow you to use the Circle R, the registered trademark, to put people on notice that you are the owner of this company name, slogan, logo, or tagline, or sound. And if anybody wants to use it, they are going to have to, either choose a new name, or they're going to have to ask for your permission to be able to use it. Sometimes business owners think to themselves, well, I don't have an immediate need for, protecting my company name or logo or slogan or tagline right now, so I am going to wait. Now, I'm just letting you know that what can happen in those circumstances is that if somebody decides to ride on your coattails and maybe use your name or something confusingly similar, then you are going to maybe question why you didn't just register at the beginning. So if your doubt really centers around not registering a mark because of financial reasons, well, that's a different story than somebody who just says, I don't really need it right now. Because the fact of the matter is that your IP portfolio will grow as your business continues to grow. Your business might look attractive to other onlookers. Your logo might be so pretty and so attractive that onlookers just can't help themselves. And that is just today's world, is that there are people doing copycat stuff all the time, whether it's copying your domain or copying your slogan, your logo, or your tagline. So the USPTO is going to be your one-stop shop for protecting something that you don't want someone else to use, or that you at least want to be able to leverage to be able to tell somebody else, I actually own that, so you can't use it. You see, you can do that if you don't have a registered trademark, but what are you more afraid of? A barking chihuahua or a barking pit bull? In my opinion, I think that a pit bull carries a little bit more weight than a chihuahua. Now, I'm not saying that you're a chihuahua if you don't have a registered trademark, but I am only using that analogy to let you know that the efficacy of having a registered trademark definitely outweighs not having one at all. Trademark fact number 4. You do not have to have a registered trademark to be able to send a cease and desist letter. So if you are worried because somebody else has already ridden on your coattails and they're already using a logo, slogan, or tagline that is similar to the one that you already have been using for a while, then lots of people think, okay, I need a rush to get a registered trademark and then I can send a cease and desist letter and then everything will be good and well, or at least I'll scare them off. And so the fact of the matter is that you don't have to have a registered trademark in order to be able to send a cease and desist letter. Now, this isn't a rule or a fact that's written on the USPTO website. No. You're not going to find it there, but that is something that a trademark lawyer, somebody more experienced and knowledgeable, probably more than the average viewer who's watching this video, will be able to share with you. So I'm sharing that information right now. You do not have to have a registered trademark in order to be able to send a cease and desist letter. However, if you listen closely to what I said just a couple of seconds ago, then you will know that having a registered trademark does allow you to have more leverage and is a little bit more powerful when you are trying to basically get somebody to knock off their dirty business. So if you want to tell somebody, hey, stop it, I own that trademark, you do not own that trademark, well, then it's a little bit more powerful when it comes from somebody who actually owns the mark, not necessarily through constructive or common law use, but somebody who owns the trademark and actually has the registered trademark certificate from the USPTO to prove it. And so, but still, nonetheless, it's a fact that you don't have to have the registered trademark in order to be able to send a cease and desist letter. But in that situation, you would more than likely be relying on common law rights. So if you are not really sure what common law rights mean, or if you have constructive use of a mark, then make sure that you watch this video here where I go more into depth on that. Fact number 5. I love it when someone tells me, Marcella, but I already did a DIY application and everything was fine, so why do I need a lawyer this time? Or you know what, Marcella, I have a friend and they did a DIY application, they did it themselves, they didn't have any issues, so I should be able to do the same. Why do I need a lawyer? Fact number 5, not everybody's trademark application is the same. It is a fact that everybody's trademark application is different. It's a fact, it's a fact, it's a fact. And again, this is something that is not written on the USPTO's website. Nobody is going to stand up and tell you this. Nobody's going to make that announcement through an ad, or, it's not going to be written on a billboard. But maybe I just gave myself a new idea. But the fact of the matter is that every single trademark application is different, and that is a fact. There are no two applications that are going to be exactly the same unless you're somebody who's refiling the same exact application that just got rejected a couple months back. But there's always an exception to the rule, right? But still, it is it's a fact. It's a fact that not every application is the same. So just because your friend didn't have any issues doesn't mean that you're not going to encounter any issues. You may or you may not, but you can't compare their situation to yours. And some of the reasons why everybody's trademark application is different, besides the obvious reasons like there's going to be a different owner, it's a different trademark, it's different goods and services, it's probably a different entity. I mean, those are the most obvious ones. But maybe some less obvious ones that you're not really thinking about is that every trademark application has an examiner assigned to it. And the chances that you get the same trademark examiner as your friend is going to be pretty slim. So let's say you're somebody who has filed 2 trademark applications or 3 applications. Your third application is not going to be the same as your second and as your first. Again, besides the obvious reasons why, because it's a different identification of goods and services, it's probably a different mark. One might be for a slogan, one might be for a logo. Okay, besides all those reasons, what's important to note is that the trademark examiner on your third application is not going to be the same as the trademark examiner from your second and your first application. So you yourself might even get different trademark examiners on every single application, even if you filed them back to back to back on the same day within the same half hour. So this is very important. The fact is that everybody's trademark application is different. Yours is not going to look like someone else's, or even some that you have filed previously yourself. So don't take for granted what might have seemed like a very easy trademark application process on the first go around, because future ones may or may not look the same. So if these USPTO facts were helpful for you, then make sure you give me a thumbs up down below. My goal is always that you learn more than you knew before you started watching. I am Marcella Dominguez, and make sure that you hit subscribe and that you tell me in the comments below whether this is going to be your first try filing a trademark application. Until the next video.